Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I would like to talk about some very good developments on the humanitarian reinstatement front and the procedures essentially that will be used in order to apply under the essentially amended and new law. So first, let me just describe briefly what is a humanitarian reinstatement. Now, let's just say that your father petitioned you 12 years ago and the visa number looks like it might be current in 3 years, 4 years from now. I mean, it takes a long time. And let's say, unfortunately, last year your father died. Okay, under normal circumstances, and the way it's been for some time, the petition itself will have also died, and you will have to file what's called a humanitarian reinstatement. And essentially what that is when it's exactly what it says: for humanitarian reasons, and there's all kinds of ways of showing that, but for humanitarian reasons, they will reinstate the petition, the I-130 petition, so that you are able to proceed forward and to go and do what is necessary in order to get the petition to go forward as though it were still active, and even though you still were able to make the wait for years and years and years proceed forward. And so that's how normally the humanitarian reinstatement works. And then what happens is you submit it, and if they approve it and you've submitted everything you need to, then they reinstate the petition. You have a substitute co-sponsor, basically, who will take over the responsibilities of showing you have money to pay so you won't become a public charge, and then you go from there. Well, they now have incorporated a new law, which I'll do some more videos in the future on the exact specifics of how you need to proceed and do this. But for all intents and purposes, if you were in the United States at the time that the petitioner died, and you are still in the United States at the time, basically you're listening to me now, then there is essentially a way of doing this without having to do the humanitarian reinstatement. You follow the new law that's been implemented based on a case that was issued, and it goes forward, assuming you can show everything you need to. And again, it's not automatic insofar as there's still discretion for, denial if they don't feel that you qualify for it and so forth. But it's 1,000 times better than having to do the humanitarian reinstatement, which of course a lot of people will still have to do because a lot of people weren't in the country at the time the petitioner died and or are not in the country now. And given that, if you know that this is going to happen and the petitioner is about to pass away, you need to do everything you can to get in the country, which, give my office a call. I'll let you know how you might be able to do some parole applications and so forth to get in. Because if there's a way of saving 15 years of having to wait in order to proceed forward, well then, there's no need to, of course, start all over again. And it not only helps you, but it helps the beneficiaries, which, could very well be your spouse and, your 12 children, whatever it is, who are all unmarried and under 21. So it's a great development. So if you're in a situation where you, the beneficiary, have been waiting for years and the petitioner died, then give me a call. I'll give you the consultation, let you know what needs to be done, and then we'll go from there. No need in some cases now to do the humanitarian reinstatement, no need to go forward and lose all those years. And even if you have to do a humanitarian reinstatement, I'm going to argue that the burden should be less now because they're allowing all these other people to go forward and just pick up the petition where it took off. And just because you happen to be outside the United States shouldn't mean that you're not able to in some way take advantage of the new law. Okay, more in the coming videos.